No, I wanted us to talk to Inusa before Abotsi. But I understand that Abotsi will have to leave us. So let's go to Abotsi now. Prof. Abotsi, thanks for joining us. Hello, Prof.
Thank you, Samson.
Great. Good to hear you. I'm very good, sir. Thanks for asking. So the majority decision in the conclusion said that we reject the invitation to reinterpret or effectively rewrite these constitutional provisions to imply that an incumbent member of parliament shall not file nomination to contest on a platform different from the one on which he was elected unless he first vacates his current seat. Such a reading imposes an undue restriction on political freedom, a constraint not articulated in the original text of the articles. The constitutional language should be construed holistically and purposively, without imposing limitations that could curtail the fundamental freedoms of sitting MPs and ultimately sabotage the rights of the electorate. Isn't this a fair reading and interpretation of the provisions, that their declarations and their filing to contest is for the future? It does not affect the current parliament. And they continue to do business. They have not changed their character by which they entered this parliament. So they should not be punished for it.
I have subscribed to the future or the futuristic aspect of the provision as the court concluded. So the court's position is one that I've subscribed to, and I've actually said this on your network in the past before the judgment came out. So I'm very much of the view that the decision really should be about the present and not the future. However, the reason the court ascribed to it, with the greatest of respect to the courts, is extremely problematic. Now, the reason it's problematic is precisely the reason of political freedom is what the Constitution seeks to constrain. The Constitution, in essence, is saying that if you go to Parliament on one promise, you do not have the pleasure, you do not have the freedom to change willy-nilly as and when you wish. In other words, while all of us can change our political alignments, members of Parliament can only change their political alignment on the pain of losing their seats and having to go back. And so for the court to therefore rationalize this on grounds of political freedom and the right of choice of a member of Parliament is to undo precisely what the Constitution seeks to prevent, i.e. the fact that you can stay out of Parliament and change your party anytime you want. That's your business and that's your prerogative. But if you're in Parliament, the promise on the basis of which you went to Parliament, you cannot change anyhow. And that is partly the difficulty, again, I have with another aspect of the decision, which I have to say, by the way, the judgment is nicely and lucidly written. I enjoyed reading it in terms of the lucidity of the articulation. But there are a few problems with the judgment. Another problem.
The one you just mentioned, let's stay there for a minute. It says MP's current parliamentary affiliation remains intact until they actively change their political allegiance during their term, not when they express future political intentions. You say this is a wrong statement of the law?
No, that's what I've said. I've said I actually subscribe to the futuristic aspect of the change. In other words, the fact that the change must be to your current membership of Parliament, not your future.
Okay, so Esiama,
I subscribe to that theory. The point I'm making is the rationalization of that I found problematic with respect. And the reason I found problematic is what I've already articulated. The fact that basing it on the freedom of choice is, in my opinion, and with the greatest respect to the court, not an accurate statement of the law in this case, because the freedom of choice of an MP is constrained. The MP doesn't have the same flexibility and latitude that we have to make choices of our political alignment. MPs don't have that. MPs must stick with the parties with which they went to Parliament for purposes of doing business in Parliament. And that's what I was going to state about the other difficulty that I have.
So you are saying that if you are changing, you are in the known that you are sacrificing those freedoms. Is that what you're saying?
That's what it is.
Okay.
In other words, the Constitution doesn't allow the changes and the exercise of the political freedom of choice. The Constitution doesn't allow that for MPs for purposes of being in Parliament. And that's what I was still going to,
still stay there. Stay there briefly for me. Stay there.
That difficulty.
Stay there for a second.
Difficulty. Because it's important to understand that for purposes of this something, otherwise this one is not complete. It's a point I'm making. It's connected.
All right.
I'm saying the other difficulty.
No, hold on. Let's just clear this before you move there. When the judgment says that MP's current parliamentary affiliation remains intact until they actively change their political allegiance during their term, not when they express future political intentions. My question is, Andrew Esiama, for example, he is independent doing business with the NPP. Now, he has filed on the ticket of the NPP. He must be a member of the NPP before he can file on the ticket of the NPP. Has he changed political allegiance or he has not?
Well, that's the point I was going to make. And that's why I said it's a completed, it's a complete set of analysis. So I'll be grateful if you can allow this. So the point I was going to make, therefore, is that as I read the judgment, I realized that the court did not speak in the positive term. The court spoke in the negative term. Now, in the negative term, in the sense that the court actually told us what does not constitute vacation of seat. What I did not see in the judgment is the positive statement of the circumstances that constitutes the vacation of seats. I think the positive statements would have been very helpful. And that's the question you're asking, which is what I've been trying to say all along.
Is this not the positive statement? Is this not the positive statement when they say an MP must vacate their seat if they leave the party under which they were elected to join another party or become independent and seek to remain in Parliament under their new political status?
Correct. That's positive. But the question is, what constitutes the leaving the political party? That is a broader statement. In fact, if you look at the contestation in Parliament, it seems that the proposers are saying that they have left the party. The opposers are saying they haven't left the party for purposes of the current Parliament. And so it would have been helpful to understand what constitutes leaving a party. Now, I can hazard some guesses, and I have to be clear. I'm not a court, so I'm just speculating at this stage. But we can hazard some guesses. For example, who does the Member of Parliament do business with? Where does it sit? How is his name captured in the Hansard? How does the Clerk of Parliament capture him in the various parliamentary transactions, records, and administrative processes? How is he even captured by the Speaker when the Speaker when he's trying to catch the eye of the Speaker? Generally, what characterization and what association does he bring to bear in terms of he being in Parliament? In other words, the constitutive element of leaving the party is a factual statement. And that factual statement is made up of elements that I would have been grateful or happier if the court had actually itemized those. I think as we stand at the moment, we have still not resolved that big fundamental question. And for the future, this thing will arise again. What has just happened represents a precedent that I'm sure other parties replicate. The next time another party is in majority and the other is in opposition, and we have a situation of independent candidature declared, we are going to have this possible scenario again. And therefore, it should have an imperative that we have a definition, a detailed definition of the constitutive element of what represents leaving the party. Because that's the expression that the Constitution uses. So the Constitution itself,
what represents leaving the party? Can we take solace in what the parties say is leaving the party when they submit their constitutions? And the court took time to speak about the fact that the Constitution requires these parties to submit their constitutions, and their constitutions must conform to the Constitution of Ghana. When the NPP's constitution says that any member who makes a declaration or who is found to be doing things contrary to the party's candidature or the party's candidate in a particular constituency, that person automatically, those are the words of the Constitution, automatically forfeit his membership. Do we understand leaving a party, what it means? Does that help?
So when we say you have left something, let's come back to basic English. When we say you've left something, it represents a voluntary departure. It's on the face of it. It's on the face of it easy to understand that you have voluntarily departed, or moved away or left something. We can easily also understand that forfeiture represents not voluntary, but it represents a self-deprivation. You haven't done something and deprived yourself, therefore, of another thing. And so if you do something you're not allowed to do, and by reason of that you forfeit, the understanding of supposition is that, again, you've lost it. So we can also add that to leaving. But what about when you are, for example, dismissed? When you haven't forfeited, you may not have done anything wrong. You may not have done something that constitutes forfeiture, but you've been dismissed for whatever disciplinary purpose or whatever the reason is, you've been dismissed. Would that constitute leaving? An interpretation may probably say, yes, the effect is the same.
The Parliament Act says so, that if a member is dismissed or expelled by their party, they will lose their seat.
Correct. So the point I'm making, as we have the situation before the Supreme Court, and as the Supreme Court is trying to do a full spectrum analysis of the elements that constitute leaving, so that we don't have any controversy as to whether or not this person is still a member of a particular party. That's the point I was making about, I would have been happier to have seen a more positive statement of the circumstances that constitutes vacation of seats. Remember, leaving is just one, but the whole gamut of things that constitutes vacation of seats. Because I really do expect that this matter will arise again. And in the circumstances of the judgment, I think we have only partially addressed it.
How will it arise again? The Supreme Court does not interpret a provision twice.
No, I'm saying it could arise again if you have a situation in which, for more complex reasons, you have a speaker of Parliament saying that in light of his own interpretation of the Constitution, somebody has left. Because the Supreme Court has still not defined the positive aspects of leaving, the positive aspects of vacancy. What it has mainly done is to tell us what it doesn't agree with as constitutive of vacancy in the current circumstances of the facts. I think the court was a bit limited by the current circumstances. It tried addressing the current circumstances in the context of the factual scenario. But the situation could arise again. And you can mark the space. The situation will arise again. And in the context of the court's decision, I don't think we have the tools enough to deal with the other circumstances that could arise over and above the current circumstances.
But you, Professor Abotsi, in principle, share the outcome to the extent that what happened, what the 4 MPs have done, should not amount to they losing their seats, correct?
It will be, I would not say I share the outcome. I think it's a bit more problematized. I would like to state that. First of all, as to whether or not this matter should have ended up in court in the first place is something that I have great doubts about. I think we are over-judicializing our politics. And it's something
Prof, before that, help me with this. The conduct of the 4 MPs, should it result in they losing their seat from where you sit? Yes or no?
If you take, again, my position on it being a futuristic thing, I would typically say that for the declared intent, that of itself should not have amounted to they losing their seats. Now, it's again a bit more complicated. So that
it is your expectation that the majority leader, Afenyo Marking, today can declare that he wants to contest on the ticket of the MPP of the NDC or as an independent, and then he files his nomination. He should still stay in Parliament and finish his business because what he's doing is for the future, correct?
No. On that basis, beyond the future, it's a bit more complicated. The point I'm making is, if he files his nomination, how do you file a nomination of a political party if you are not a member of that party? Virtually all the parties in Ghana have membership as a requirement. So if you file and if you have filed and you have been announced on the electoral register, it means that you have become a member of that party. So in terms of the factual circumstances, you would have left the party on the basis of which you're elected. So I'm just saying that these things, look, the futuristic aspect of it.
If you have left the party in the circumstance you just described, should you lose your seat?
Absolutely, you should.
You should?
Because It's the statement, yes. It's a statement
but the Supreme Court puts a stress.
And in fact, the Supreme Court has
the Supreme Court put a stress on an incident that is a condition precedent, that you must seek to remain in that parliament under your new character. So Afeyomakin files to contest as independent, or he files to contest on the ticket of the NDC. He must seek to remain in parliament under that new character. Otherwise, he doesn't lose his seat. You disagree with that?
No, I don't disagree with that. I actually absolutely agree with that. And that's why I said it is a multi-purpose test. And that's why I would have wished that the court had actually stated this in a corporate global term so that we have a clarity on the matter. You don't just leave a party, so to speak. You have to leave a party within the context of your representation in parliament. Remember, Article 97 is focused on your representation, not your membership or otherwise of a party in the abstract. It is focused on your representation in parliament. So how does your membership of the party affect your representation? And that's why I said earlier that how are you captured, for example, in the Hansard? In the debates, how are you captured? In terms of the speaker, the clerk's administrative incidents, how are you captured? How does the speaker recognize you?
Okay.
There must be a multiplicity of factors in terms of your representation. And I would have wished that, again, the decision stated that in more positive, concrete global terms, so that we have a composite statement of what constitutes you leaving the party, but beyond that, what constitutes vacancy.
Okay, so now help us with this. Let's know where you stand. That Article 2, Clause 2 of the Constitution says that for the purposes of giving effect to the declarations that the Supreme Court makes, let me read it, Article 2, Clause 2. It says the Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, and Clause 1 is when you come to complain that somebody, Clause 1, let's read it. Thank you. Let's read it this way. A person who alleges that an enactment or anything contained in or done under the authority of that or any other enactment or any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. So Afeyomakin went to court for a declaration to the effect that the Speaker has interpreted the Constitution but wrongly. Then 2 says the Supreme Court shall, for the purposes of a declaration under Clause 1, which I just read, of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. Do you share the view that in the absence of declarations in the terms of Article 2, Clause 2, this judgment is a brutum fulmen? It's an empty judgment. Do you share that view?
Not at all. I don't think it's a brutum fulmen. I think it's unusual that the Supreme Court typically would have given a judgment without an order, because the order is perfect and complete judgments. But it's not brutum fulmen. If you look at the Constitution under Article 1, Clause 2, it says anything done inconsistent with the Constitution is void. Therefore, where there's a declaration of anything having been done in violation of the Constitution, the declaration essentially is saying that that act is void. So even if it is not capped with a consequential order, under the principle of what we call in constitutional law, nullification impairment, the statement of nullification that makes it void impairs any action against the void conduct. So even without a consequential order, you are not supposed to act pursuant to the void order. So the principle of nullification impairment deals with that. It doesn't have to be capped with an additional order for a particular conduct in one direction or the other.
Right.
The fact that you've been told that you're doing it wrong implies that the act has been nullified and your further conduct in that respect has been impaired.
Is there a problem to the effect that there's no order or direction at the Speaker or the Parliament? The Speaker was the first defendant, though.
Not at all. That's the point I'm making about the nullification impairment. There's no, but it's important to put this in context. I think one thing that lots of people haven't realized, that the Speaker really did not make any orders for purposes of him being injuncted, and therefore for purposes of him being given orders. In other words, the Speaker made a declaration of a status quo. What the Speaker did was to declare that seats have become vacant pursuant to Article 97. So he simply declared the status quo per the Constitution. When someone makes such a declaration, you only need a counter declaration to stop that particular declaration. You don't need an order, because to stop the Speaker will be to stop him from doing nothing. He hasn't done anything. He hasn't put armed policemen at the entrance of Parliament, preventing these members of Parliament from taking their seats. He hasn't made an order for their names to be struck from the register, for example, of Parliament, or the Hansard. He hasn't made specific orders of things that should be done, which should have been reversed per order. What the Speaker did was to make a declaration. So the Speaker's conduct was declaratory. Therefore, a counter declaration solves the problem. He doesn't need to be directed to do any specific thing, because he hasn't even done anything. And that's why when I hear arguments about contempt, I wonder, what is the Speaker going to be held in contempt of? Because he hasn't really done anything. All he did was to make a declaration of a status quo. It is the members of Parliament, NDC and MPP members of Parliament, who have been squabbling on the question of majority and minority seats and who does what pursuant to the Speaker's declaration. So the Speaker himself did nothing. He only made a declaration which has generated a furore. And so making an order against him rather would be the order brutal for me, if you ask.
Do you share the view, and this will be my last question to you, that maybe last but one, because we come to jurisdiction, which I want you to be brief about. Do you share the view that this particular statement in the lead judgment is the reason no orders were made, so to speak, and that this is seeking to say that if you want to get orders specific, you should rather go to the High Court? It says that the suit essentially hinges on a pure question of law, specifically the proper construction of Article 97(1) G and H, to establish the legal threshold for triggering its provisions without delving into factual disputes regarding seat vacation in Parliament. Please note that it is to make the interpretive job without delving into the factual disputes regarding seat vacation in Parliament, which properly lies within the High Court's purview under Article 99 of the Constitution. Accordingly, to the extent that the exclusive preserve to settle a matter of interpretation under Article 2(1) and Article 131 and 2 lies with the Supreme Court, it is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court. Make note of that. To resolve the interpretation for the application of the High Court. The decision of this court in ex parte Zanator 1 cited supra refers. Let's hear you.
Well, I can't tell whether that's the reason orders were not given, consequential orders were not given. But as I indicated, the lack of consequential orders in this case, frankly, for me, is not fatal. It's a declaration of unconstitutionality is enough to address the void nature of any order or action, and therefore it addresses that. The question of jurisdiction, however, is more difficult for me to accept, and I would have wished that the court had actually ceded jurisdiction to the higher courts. Now, I'll tell you this is the reason. The Constitution is structured to respond to specific needs, and the clarity of the Constitution in terms of separating things cannot be ignored. The determination of the petition on who the President of Ghana is, presidential petition, is left to the Supreme Court. The determination of the parliamentary election, any petition for parliamentary election, is left to the High Court. What the Constitution framers sought to do was to create a bifurcated arrangement in which the Supreme Court is in charge of things presidentially, and then the High Court is in charge of things parliamentarily, so to speak. This cannot be mistaken. And I think that the reason for that is that the framers intended that the Supreme Court should not be overburdened unnecessarily by the 200 and something people who have been elected. And since we have one high court scattered across the country, and there are different high courts closer to different constituencies, let's leave parliamentary business or the decision of who has been elected to parliament. Let's leave it to the high court. Now, if you look at the framing of Article 97, which you read earlier, Article 97 contains an implicit interpretation. So even though the Supreme Court has exclusive jurisdiction, under the rules of interpretation, which all lawyers or law students are taught in law school, the principle of the generalia specialibus principle, where you have a specialized provision dedicated to a particular entity, and then there is a derogated general provision, the law says the special provision reigns. So even though Article 130 and Article 1+2 gives the Supreme Court exclusive jurisdiction in constitutional matters, Article 99 specifically vests the High Court with just that small specialized area of dealing with matters concerning Parliament, so that even if they do contain some collateral aspects of interpretation, the Constitution has given that to the High Court. And if you look at the provision, it says the determination of whether there has been a vacancy. There cannot be a determination without implicit interpretive matters that are collateral to that determination process. And those implicit collateral determination matters are not derogate, they do not derogate from the overall Supreme Court mandate of exercising authority in terms of the interpretation of the Constitution. So I think that when it came to
Prof. Abotsi, once again, don't you see that in the portion I have read to you, there appears to be a concession to what you are just saying? They say that this suit essentially hinges on a pure question of law, specifically the proper construction of Article 97, 1G and H, to establish the legal threshold for triggering its provisions without delving into factual disputes regarding seat vacation in Parliament, which properly lies within the High Court's purview under Article 99 of the Constitution. And they proceed to say that they will do this, and they said that it is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court. Is that a concession?
Well, I mean, you can give that concession that the Supreme Court is trying to clarify things. The Supreme Court is trying to bring some clarity on how the High Court should exercise its jurisdiction. If that is the intent, which we can glean from the judgment, then it's not a bad intent, to the extent that the High Court will now be better equipped to exercise its Article 99 jurisdiction. I would have rather expected that perhaps the Supreme Court could have assumed jurisdiction in terms of the scope of Article 99 for the High Court to exercise, but that is not the question before it, and therefore it could possibly go into that.
So that this will mean that the Supreme Court is saying, now we have interpreted this provision, so you can always go to the High Court to apply it, and the High Court cannot apply it differently to determine whether there's a vacancy or there's no vacancy. They will be guided by the decision we have made. Is that not what they are saying?
Right, and that's the point I'm making, that with that intent in mind, it's not a bad intent. It's a good intent. It's almost like the court saying, look, we are going the extra mile of clarifying a position. Moving forward, the High Court is equipped. I think the only difficulty, as I indicated earlier, is that even in that, I did not see the full scope of determination of the circumstances of how a vacancy occurs. I think that the court could have probably given us much more indications of the various circumstances. I think it's still a bit too general, and that's why I worry about the future.
Thank you very much, Professor Abotsi.